Hello, and welcome to this week's video blog on the law. Today we're going to discuss a common defense used by insurers and defendants in personal injury lawsuits. The doctrine of voluntary non-fit injuria, otherwise known as the voluntary assumption of risk. Sounds fancy, but it essentially means that if somebody willingly puts themselves in a position where they know injury may result, they may not be successful in a claim against another party. Voluntary assumption of risk is commonly argued together with contributory negligence, which we have discussed in previous video blogs. This doctrine is narrowly applied by the courts. This is because if it is established, it acts as a total defense against a claim. Despite this, it arises commonly in cases where a person is injured while participating in adventure activities such as whitewater rafting, bungee jumping, or skiing. To rely on this doctrine, it must be shown that an injured party was fully aware of the risks involved, both the type of risks and the extent of the risk. The defendant must also show that the injured party consented to accepting these risks and waived any possible claim for damages. This means that a defendant must show an injured party assumed both the physical risk and the legal risk involved in an activity. However, generally this defense is not so easy to prove. In fact, it can be very difficult to show that a person has assumed the entire legal risk. A defendant may rely on the implied consent of the injured party to establish this. That is, the injured party's actions or words show that they accepted all of the risks of an activity. It is much more common for an injured party's consent to be proven by contract, however. For example, before participating in an activity, a person may be asked to sign a waiver or release agreement that expressly limits their right to sue. Another common example is a waiver or release printed on the back of a ticket or posted on a sign at the premises. However, the wording and placement of these waivers and releases is critical. Even if you've signed a waiver, if the waiver is insufficient, a defendant cannot rely on this defense. Whether a waiver or release is sufficient depends on the specific facts of each case. We discussed this in another blog you can find on our website. I hope you've learned something about the law from this blog. Please feel free to like us on Facebook, follow us on Twitter, or subscribe to our YouTube channel to receive notice of our future weekly video blogs on the law. Thank you.